Hi, everyone. Carl Steinbeck here. Just wanted to jump on tonight. I originally was going to try to come on 7 or 8 Central Time to cover the closing argument and comments I have on that, on what Karen's defense team can do to revamp the one they did last time. And what I decided to do is switch that around to tomorrow night. Want to cover that tomorrow night, and I already got notification sent out. That's 5 o'clock Central Time. And so keep in mind that whatever time is showing up, the announcement is showing on YouTube, if you get it, because a lot of folks, including myself, don't get YouTube announcements you request to follow for channels you request to follow. And so in any event, it's always your local time. So if I tell you 7 or 8 on my time and that's not your time, you shouldn't have to do any calculation based on your YouTube channel. Whatever time zone you're in, it should automatically adjust for that. So I noticed there's some chatter here tonight saying, well, what time zone does that mean for me? It automatically should populate the time zone for whatever location you are anywhere in the world. So, yeah, some people get notifications, others don't. But in any event, so that's with Good Friday. Hope everyone's having a good Friday, celebrating this event. We are, I had to move my schedule around, so I decided to do this one late here and cover this new motion that came out from none other than Hank Brennan. So I'm going to go ahead right away and show that here. And hold on, I want to get this motion here so you can easily read it, or at least somewhat read it better. This is called Commonwealth's motion regarding defense's opening statement. So it's just a very short one-paragraph spiel here filed on April 17th. It says the Commonwealth moves for an order that defense counsel refrain from claiming in their opening statement that any of the victim's injuries were caused by any person or animal that was inside the home of 34 Fairview Road. Based on defense's request to show the abrasions to the victim's arm in opening statement. Remember my last live stream, I said, it's either going to be a photo of showing John and Karen embracing, or it's going to be a picture of the arm. The arm says it all. And so they're going with the arm, apparently, from this. And so it says, based on the request to show abrasions to the victim's arm in opening statement, why don't you call it dog bites? The Commonwealth notes that the court has ruled that the defense is precluded from mentioning any reference to third-party culprit claims prior to establishing a viable basis supported by admissible evidence that any mention of third-party culprit claims relative to the abrasions would be improper. So this is so radical. This is so extreme. I can't even believe that an attorney, the specially appointed assistant district attorney, he's a hired gun to do nothing other than deprive Karen Reed a fair trial. Okay. The public announcement that the district attorney's office put out saying they were hiring him, despite the fact they got 50 some attorneys in that office. They're hiring this Hank Brennan because they're trying to guarantee her a fair trial. Can you believe that garbage? A fair trial? You're going to hire somebody for hundreds of thousands of dollars, all because you're worried about Karen's fair trial rights? Yeah, right. Look at this absolute trash here of a motion, which is so unconstitutional. It's such a embarrassing disgrace as an attorney to see this. As a prosecutor and somebody, we are sworn to uphold the Constitution, okay? And this guy right here shows either doesn't get it or he intentionally is violating it, okay? So which is it? You choose. But this thing is so much basically just gagging the defense lawyers to the point that all they can say is that she didn't do it. That's all they can say is opening. She didn't do it. She didn't do it, ladies and gentlemen of the jury. She didn't do it. We can't tell you what happened. We can't tell you our theory of the case of what happened because this whole process is hijacked by this judge and this rogue prosecutor that are basically just tag teaming to constantly deprive Karen Reed's team and Karen Reed the constitutional rights she's afforded. And I'm telling you, this state of Massachusetts is an absolute abomination for what I've seen on cases. I'm looking at these cases that the judge is citing in different rulings she has. None of them make any sense. They don't follow normal states. They don't follow federal law. Notice she never cites federal law on her rulings. She just cherry picks the ones that she can align with her. And so I would say that they're going to get a rude awakening. If there's any kind of conviction here, they're going to get a rude awakening. And I've said before, the only way Hank Brennan can win this case if he hides the truth. What's he doing here again? He's hiding the truth because the truth shows that Karen Reed should have never been prosecuted. She should never be convicted. And this whole case needs to be shut down. And they need to go after and regroup and go after the right people who did this. But what are they doing? They're trying to hide the truth because guess what? When the truth comes out, people think the same thing that all those people that are outraged over this, that are protesting because they know, they've seen the evidence. They know how dirty this location is, how dirty the law enforcement is, how corrupt it is, how corrupt it was just on the Sarah Birchmeier case. They're just as dirty and corrupt, if not more, on this case here. And unless the feds step in and do something about this case, Karen's just going to be strung along out there with these radical, extreme rulings and motions. So think about, let's go back to think about what this is saying here. So you can't even say what the injuries came from. Not even a dog. You can't even argue that a dog caused it. So what is this to say here? So it has to be like some stranger in the night came by or some random dog came by. It couldn't have been Chloe, the dog of the Alberts at the home there. So the cover up that went on from the night this went down, all the cops circled the wagons. They had a cop down, but you know what? It happened right in front of a cop's home, actually between two cops' home. One was a Boston police officer, detective type, Albert. It was in his front yard, and across the street was another deputy chief of a division there at the Canton Police Department. And you have a Boston cop that's found dead in the yard. And this was not treated as if this was anything other than a cover-up. They didn't want the truth coming out, and the sloppier job they did, the more that they could have a chance to dispose of evidence and also plan evidence. So this motion here, when no prosecutor with a duty to uphold justice and to give defendant a fair trial would submit this kind of motion unless they really thought the judge was just going to rubber stamp their wicked and evil ways of doing this injustice against Karen Reed. So this should not fly at all. This should be like bounced right out of the courtroom. This should be having no credibility whatsoever. Keep in mind, the judge talked about third-party culprit. She's already shot it down for Colin Albert, who actually has bloody knuckles, as if he got in a fist fight. He had bloody knuckles that were seen in a Facebook posting. And so he is one that they try to point the finger at, the defense did, as being a possible suspect, a culprit for this. The judge says, well, there's not enough evidence to show that he could have had any kind of axe to grind with the John O'Keefe. So it's just so ludicrous to say that the defense has to come up with some kind of long-standing axe to grind against either Colin Albert or even the other two Brians, Brian Higgins, the ATF agent, or Detective Brian Albert, because things can happen in a flash. Just think about road rage incidents. Those can happen in a flash. So according to Judge Cannoni, if there's a road rage incident and there's like 8 people in one vehicle and 2 people in another, and one of the cars, the one with two people, have someone get out of the car and they're just like beat to a pulp, and the cops show up right as everyone's back in the vehicle and they're trying to both take off. And they would say that essentially, if they wanted to blame it on the driver, the person who was riding in the two person in the vehicle, and they try to blame it on the driver of that and said, your passenger, we think you're the one that beat him. In the bat we found on the side of the road with pig DNA. We didn't find your DNA or the other guys in the van's DNA, but we can't find any motive. The guys in the van behind you had any axe to grind. There's no longstanding history of disputes between the deceased and the guys in the van. So it must be you because you know him. So you can't point the finger at your trial to say that in this road rage incident, the van with 8 guys in them had any incentive or motive or any reason at all to try to beat your passenger to death. So it must be you, the driver, that must have beat your passenger to death. So it's just so ludicrous. And what it does, it just shows that this judge is coming up with any kind of just off the wall, ridiculous argument based on fact and coming up with different interpretations of law that do not cover the law completely, do not cover federal law that also is very much at play here. So it's very much looking like this is going to continue on and on. This guy was hired to do nothing other than what he's exactly doing: cut her off the knees. You might as well tie up the defense counsel in their chairs, blindfold them, gag their mouths shut, and just have them sit there and just basically not even do any opening. I mean, if this was me and I was a defense counsel in this case, I mean, I would go live it in that courtroom, explaining how you basically are causing me to be ineffective, which is another constitutional violation that would reverse this case. You're causing me to be ineffective, and that will reverse this case because I am not able to even say what happened to our defense theory. What our defense theory is, you're completely shutting me down. The only defense theory I can come up with that you allow, judge and prosecutor, is to say that it didn't happen. Everything the prosecutor says, just think the opposite. It didn't happen. And we can't tell you why it's the opposite, but we can just tell you that, you know, it just didn't happen that way. So it's never going to fly on appeal if there's an appeal. And I wanted to show this other case to y'all. I've talked about it before, but I've not presented the case it's for you. And so this one here, this is a landmark case, Washington v. Texas. This is in Dallas County from 1967, but it's a landmark case. It's frequently cited in courts across America, except in places like Massachusetts, because they apparently don't follow the Constitution, even though it applies via the 14th Amendment to all states equally. So here, the Supreme Court, I'll try to just not get into much of the facts, but essentially there was some kind of a shooting that went on. There's multiple suspects, and there was somebody that was killed. And the question was, who pulled the trigger? Who was in what car? And the defense Washington wanted to bring out one of the other co-defendants. And there was a state statute in Texas that denied co-defendants from being able to call other co-defendants in a felony case like this. So the statute was at play here, and the judge followed the statute and denied the ability for the defendant, otherwise called the petitioner here in the Supreme Court case, to be able to call these witnesses. So the court looked at the 6th Amendment and the 14th Amendment and the 5th Amendment. 5th Amendment is called the Due Process Clause, and the 5th and 6th Amendment are applicable to the states via the 14th Amendment. And so the highlighted portion here says, it says, in recent years, we have increasingly looked to the specific guarantees of the 6th Amendment to determine whether a state criminal trial is conducted with due process of law. We have noted that due process requires that the accused have assistance of counsel for his defense. So if you don't allow me to argue for Karen Reed on what our theory of what happened is, you're denying that essential assistance of counsel to be confronted with the witnesses against him. So you should be allowed to cross-examine and confront the witnesses against you. All the people in that house, you should be able to confront with their motives. And if they don't admit it, then you can try to impeach them. So the fact that they won't admit it, let's say this goes to trial and they don't admit that John O'Keefe ever came to the house, they had nothing to do with attacking John O'Keefe, they could deny it, but the jury could actually believe that they did it based on how their demeanor is, how they answer questions, all the lies they got tripped up on, all the ways they try to get their story straight, the way they try to discard phones, the way they had butt dials. I mean, you could go on and on and on talking about these indicators that there is something really astounding that happened that night with these folks in that house that made them really scurry to try to cover their tracks. And that's what it looks like. So why would they try to cover their tracks? And the defense needs to argue to adequately represent Karen that something happened in the house, and we think it's most likely these 3 folks that did it. And there's actual evidence to show that something happened to John and he was inside the house because he moved up 3 flights of stairs. That's shown from his Apple Health data. And because he moved up and down 3 flights of stairs, guess what that means? That means he was in a house. What other house would he have been there at 34 Fair other than 34 Fairview, right? So, and he also got to the house. We also heard from Jen McCabe saying he got out of the car. So if he got out of the car, and Jen McCabe vouches for that, and she's also saying where to pull up to park. So, and we know that Karen Reed was already back at John's house at 12:36. So she was already gone by the time we still had activity of John moving around and his phone being shut off at 12:32. So she was no way around when activity is going on with John O'Keefe and his phone and his body. So that proves that something's going on, and there was somebody in the house had something to do with this, right? So, but the fact that they can't even bring this out. So let's go on and look some more of this case holding here. So it goes on to state here in yellow, a person's right to a reasonable notice of a charge against him and an opportunity to be heard in his defense. So that right there, they're trying to cut her off her opportunity to be heard on her defense, a right to his day in court, in this case, her day in court. How are you having a day in court if you can't even present your argument you want to and present your witnesses you want to? You can't even present an expert witness that directly contradicts a government witness who they're trying to hold out as an expert. Their cops are trying to hold out as experts, and yet you can't bring a defense expert to contradict what they say. It's an absolute sham. This is not American justice, I can tell you that. Our basic to our system of jurisprudence, our basic. Well, you don't even get the basics there in Massachusetts. And these rights include, at a minimum, the right to examine witnesses against him, to offer testimony, and to be represented by counsel. The right to examine witness against them. Again, this judge is trying to cut them off from being able to cross-examine the folks in the house because they know these witnesses can't hold up. They can't hold up to the cross-examination scrutiny, and they want to put their hands on the scale and make sure Karen is convicted by the truth not coming out. They just want to claim this is irrelevant. There's no way. The judge has already deemed, because 8 people said that he didn't come in the house. It's almost like a fact finder of the judge. She's making like a ruling as a matter of law that these guys, that because these 8 said that John O'Keefe never came in the house, that he never came in the house. He's also almost making that like a finding of law that John never came in the house. Well, guess what? The judge is supposed to let the jury decide. That's a matter for the jury to decide who's telling the truth. What is the truth? Okay. She's just there to instruct on the law. She's not there to cut off at the knees and bound and gag the defense from presenting a case. And that's exactly what they're trying to do here. It goes on to say the right to offer the testimony witnesses and to compel their attendance, if necessary, is in plain terms the right to present a defense. So the right to offer testimony to witnesses. So in other words, whether they're through cross-examination or for you calling them via subpoena to the witness stand and you calling them out on all their different inconsistencies, all their different motives, that's what a trial is about in America in a criminal law setting. And yet you don't see hardly any of that going on here in this case. It's such a disgrace. The right to present a person's version of the facts. Listen to that here. The right to present the defendant's version of the facts. That's what the Constitution is about, allowing you to present your version of facts as well as the prosecution's to the jury. So the jury has a right to present their version of what they say happened that caused this death of John O'Keefe, and the defense has a right to present what they say happened, and then let the jury decide it, right? But that's not the way they want to run it here in Massachusetts. They want to have it where the truth is hidden. There can only be one option, but either Karen Reed did it or she didn't do it. There's nobody else that could possibly be responsible. So that is such a sham court of law. If this goes down and they can't even say what their opening statement is going to be about the theory of the case, and this third party culprit thing right there, this is her ruling, and where she's saying it's barely meeting the standard to get the third party culprit defense in for the 2 Bryans. I mean, this is like right smack in the face, just shredding this constitutional provision that says you have a right to present your defense. So, and this goes on to say that he has a right to Just as an accused has a right to confront the prosecution's witness for the purpose of challenging their testimony, he has a right to present his own witnesses to establish a defense. So right there, this also goes with the retired law enforcement officer, FBI agent Easter, which the judge denied. So this is going to get busted on appeal. As I've said in another video, this is going to be guaranteed to be busted on appeal. And look what it says here. This is a right. This right is a fundamental element of due process of law. So this is so basic. It's so fundamental. It's not far-fetched what I'm saying. What is extreme and outrageous is what the prosecution is doing. And then like I say, what's really bad about it is that the judge is just rubber stamping all these radical things the prosecutor is trying to do, almost in toto. Not all of them is she allowed in, but it's just like way out of control. And then there's some interesting history here too. It goes on to say that Joseph Story, in his famous commentaries on the Constitution of the United States, observed that the right to compulsory process was included in the Bill of Rights in reaction to the notorious common law rule that in cases of treason or felony, the accused was not allowed to introduce witnesses in defense at all. So keep in mind, the common law rule back in England was that you couldn't present any witnesses in your defense. The British government, prosecutors, the Whigs, they could present their evidence, the barristers, whatever they call them over there, they could present their evidence, and you can't call your own witnesses. So think how you can easily be railroaded. It's almost that bad here in Massachusetts. And to think this is like where our founding fathers said enough of this kind of stuff. We're standing up against this. And now we're seeing this revert back. I mean, these guys would be rolling over their graves if they saw this kind of stuff going on right now with this kind of guy, Hank Brennan. And it goes on to say, although the absolute prohibition of witnesses for the defense has been abolished in England by statute before 1787, the framers of the Constitution felt it necessary to specifically provide that defendants in criminal cases should be provided the means of obtaining witnesses so that their own defense, as well as the prosecutions, might be evaluated by the jury. So anyway, it goes on to basically toss out this conviction against Washington, saying that this is an unconstitutional ruling by the court there in Texas, keeping out the right to call witnesses. So the same kind of thing is going to happen here in this case. If Karen Reese gets convicted, if she's acquitted, then there won't be a reported case that goes up on appeal. The prosecution cannot appeal a case and have it retried for that reason. So, so going back then to this motion and ruling by the prosecution to try to keep out third-party culprit defense. Notice here all these cases cited here. Judge Cannone initially talks about meaningful opportunity to present a complete defense. And that's Massachusetts case citing Crane v. Kentucky in 1986 case. But, the rest of this stuff is pretty much all talking about Massachusetts. And Massachusetts is really behind the times on due process. It's very much a strange system of justice up there where the judge is so much able to influence who's on the jury. She picks the foreman, the way the alternates are selected. There's no transparency. You have a raffle basket or a tumbler and some assistant to the court that's rolling it and then pulling out numbers. How do we know all the numbers are in there like they're supposed to be? Why isn't the defense able to see that? Do you know in other jurisdictions where they have that, the defendant is the one pulling out the names or the numbers of the alternates that will be excused? So it's really eye-opening. I had no idea any states were this bad here in the criminal law setting. And as Judge Cannone always says, well, this is the way we do it here in Massachusetts. Well, guess what? This is not the way we do it in most states in America, and certainly doesn't operate that way in federal court. So with that, I'll go ahead and turn over to your questions. And so if you have a question, it's probably easiest if you repeat it. If you put it up earlier than now at 10:28 my time. And if you can use the red emoji question mark, that way I can distinguish between the internal chatter and if you have a question for me. Pebble, what you're saying, not much has happened in Norfolk County since the witch trials. Okay, flightless. I've not heard anybody else comment on this. You've saying you've heard at least 4 experienced trial attorneys say that this motion is a complete joke. I'm optimistic, but I can't believe this is real. I had one kind of motion like this where they tried to deny a third party culprit and was able to win it anyway. But it was like so appalling. I knew I was going to win it on appeal if there was a conviction, but the defendant got acquitted, so it wasn't an issue on appeal. Psychology of 9 years. Anybody who believes it's not political, as well as not seeing the whole picture. If the overseers are all complicit, corrupt, they have free reign. So I'm going to go ahead and take it out of presentation mode. Let's see here. Yeah, LA can't even vote her out because judges are appointed. Hey, H, you're saying, is there anything anyone can do to make this right? I mean, right now for the trial, the defense has to continually object, and it's just an absolute complete, as I say, a railroad job. This is not about justice; it's about vengeance, and just complete trampling of the constitutional rights for Karen Reed. Yeah, I mean, to me, it's like when you go to this extreme to deny somebody a fair trial, it's like it's just so much as a thing that is shameful and disgraceful that we don't deserve as a rule of law in a constitutional um, framework government. We don't deserve to prosecute people if we can't abide by our laws. If our laws are just meaningless and we prosecute people, even guilty people, but our laws are just a complete farce and they're looked the other way and they're just completely ignored, then we don't deserve to convict even the guilty. So we are supposed to make sure, think about our justice system, we're supposed to make sure that we don't have the innocent that are convicted. We'd rather set a guilty person free than convict an innocent person. So that's what we're looking at, where they don't care. They just absolutely do not care about affording Karen Reed a fair trial. Pebbles, you're asking, is that the judge asking the prosecution if they want to check, is that normally allowed in other states? It seems extremely biased and not the role of an impartial judge. I had a biased judge that was doing that in my criminal cases. He'd never been a defense attorney, he'd only been a prosecutor before he went to civil practice. And he objected, or he basically told the prosecution how to object because they didn't know how to object to stuff. And so it's not that common, but sometimes you do come across judges like this. But Judge Canoni, I've never. This is like mind blowing how off the rails biased she is. All right, let's see. Libby C, is it normal for a judge to rule on a motion for their own recusal? Yes, I've seen that before, where a judge basically sets forth the reasons, the grounds why they don't need to be recused. But I think there's still other things other than like what was noticed in this Facebook account where they call her Aunt Bev, and I guess they're going to some McCabe's are going to visit at her beach house, and she denied having any connection with the McCabe's and stuff like that. But what about her connection to Morrissey? Supposedly, there's a longstanding connection between Morrissey's mother and Judge Cannoni's mother. They both work the same, I guess, lunchroom or something. And so that's how she got her appointment. Trust me, she did not get nominated to the bench without somebody like Morrissey recommending her to the governor. She got appointed by the governor of Massachusetts. And as a defense attorney, or excuse me, a public defender, how do you have time to hobnob with politicians to get your name in the ring to be able to get a judgeship? A judgeship is, hard to get as an attorney. A lot of attorneys would like it, but they can't have the kind of political connections to get that kind of job. So how does she otherwise have political connections if she's like overwhelmed and swamped as a public defender? So something like connection like Morrissey, no doubt, could have had an impact on that. Fierce like Frida, you're saying, what do I think Hank Brennan's opening statement will cover? What highlights do you think he will leave out? I think that him trying to cover things that Karen said, it looks like in his motion, he wants to have things Karen said admitted into evidence. And so maybe some of her interviews and stuff like that, they want to have admitted in there. And I'm just telling you, that's a slippery slope. I don't agree with what the defense did in terms of having her go out there and make all these statements. And defense counsel, a lot of times you see Ellen Jackson with her. And when she's with Ellen Jackson and then she's making a statement, and sometimes they're both talking one right after the other. And if you use a statement like that and you're trying to impeach her with something she said, you're basically trying to say that this defense counsel should not be trusted. If you're trying to impeach her, you're also trying to impeach him in the process by default. And if you're basically saying that this lawyer is not to be trusted, you're almost setting him up as an ineffective lawyer. And so I think that the more he tries to show videotape and audio tape and whatnot of her giving statements to media and she's got a lawyer there, someone on her defense team, I think it's setting up more for ineffective assistance. And so but like I say, I don't think Brennan really cares. I think all he wants is to win. And so by hook or crook, he's going to do it. He's going to try to trample on every kind of normal thing you see in a trial just to be able to get a conviction. And that's mainly keeping out the truth. Lawyer, you're asking, is Karen's only hope local citizens, lawyers, and judges speak out publicly? I fear they want a conviction and don't care about an appeal. Well, yeah, of course the Commonwealth, they're in the DA's office. They want a conviction. They want this to wash their hands clean of this. They don't want to admit how bad of a job they did. Think about it. If there's an acquittal across the board on this, what does that make the citizens there in that community think? Well, if you couldn't prove it against Karen and you're so sure of it, what does this jury think about it? And then when it comes out how the jury thinks that no, it was having to do with people in the house, what are they going to do then? Still not further investigate it? So I think, yeah, people should be talking, people should be discussing it publicly. And I think I don't know how much the attorneys are talking about it locally, how much they're following it, but it's this is just such a bizarre situation there that you'd never think would happen in America. I mean, even this speech-free zone, protest-free zone, and even just support-free zone that they have established a couple blocks from the courthouse. I mean, that courthouse is basically looks like a ghost town in a combat zone, and all those barricades and everything keeping people away. And I've just never seen like it. I never thought we'd have this kind of a situation here in America. Animal lover, you're saying what was the amount of blood loss up to the trial one? There were mere drops were found, suggesting it was moved after the fact. I think it was like 3 liters of blood that were lost by John. So yeah, where's all that blood at? That would also suggest that he had moved. So when they say there's no evidence he was in the house, well, guess what? Where's all that blood? How did he go up and down the stairs? I mean, there's numerous indicators like that he had to have been placed there after some injury, and it wasn't being struck by a vehicle. Okay, some golf girl saying in the Turk trial in the same courthouse, they made sure all the numbers were there and showed the numbers, not in Judge Canoni. So that's interesting. So I wouldn't trust anything. I don't care who it is pulling up the numbers unless I see all the numbers in the raffle wheel ahead of time, and I can verify that you actually pulled the one out, and they're not all multiple numbers. You're just not saying numbers that you want to have read off to exclude. Then I would not trust that process at all. Kate is asking, has the judge chose a foreman yet or foreperson? Usually that's done after the close of the evidence and arguments that the judge, I guess in Massachusetts, they'll pick the foreman. I mean, it's just so bizarre for the judge to pick the foreman because it gives the opportunity for them to see which one do they think is most pro Commonwealth, and that's putting your hand on the scale of justice, and I just don't like that at all. Because I really believe if we wouldn't have that foreman that they had on trial one, I think Karen would have been completely acquitted across the board. Colin's speech therapist is saying one of the biggest issues for me in the first trial is why the defense couldn't mention how ARCCA got involved. ARCCA's the whole case and the dog bite experts. Yeah, and exactly what we heard from that juror named Ronnie, where he said that what they thought they were with the insurance company. Well, guess what? Insurance company is biased to want to say no, that their insured wasn't responsible. So they just basically tossed their credibility out the window. So that's exactly why Hank Brennan doesn't want ARCA's information coming out, and also Morrissey has said they don't want this information coming out to the jury that ARCA was hired by the feds. That gives them automatically the credibility that can overshoot anything that Brennan tries to bring forward now, and that's why he wants it out. That's why he wants it out, and it's an absolute absolute indicator that this whole trial is a farce. There's so many things over and over and over again that just a normal thing that happened in trial. You don't get that here in Massachusetts on this case. Dusty Blue, you're saying Hank wanted a readers for text. Do you feel like defense should ask the judge for an AI voice than human best, so no voice inflection mess ups by human? You shouldn't have to have anybody read it. You just present it up on the screen. Or sometimes you can have like the officer saying, "Oh, this is what we got, and this is what they are saying between each other." But you don't have some independent person there. And I saw the defense rebuttal to that today. It essentially was saying the same kind of thing, that this is not a text message conversation, should not be converted to a verbal discussion. It wasn't that in real life and shouldn't be replicated that way in court because it can give the wrong impression and it's not following any kind of statutory authority. G. Lander, you're saying, is it explained to the jury that not guilty is not the same as innocent? I'm concerned that some may hesitate to vote not guilty. They think it means she's innocent. The jury instructions, I don't believe they cover that well, but that's something that I can cover tomorrow night when I discuss the closing arguments. That's when the defense counsel can really go through that and make sure the jury gets it. And they need to get it this time because they completely botched it the last time. Yeah, fat, dumb, and happy. You're bringing the same point about the trial next door. The Tumblr was to select alternates, and uh, the clerk showed the juror numbers to the party. So that's the way. That's the way it should be if they're going to do it that format. Andy School, you're saying in defense bringing up other cases of how law enforcement falls in line to not let a colleague face consequences because of bad acts. That's something that can really be hammered home with Trooper Paul. Trooper Paul, I believe, has a conscience about it. I think he knows he's just making stuff up out of thin air. And I think if you pushed his buttons the right way, I think it'd basically fall apart on the witness stand. And so I'd bring up the fact that if he doesn't go along with what they said happened there at the scene, that basically he's looked at as as somebody that is a complete he's basically anti, I'll just put it nicely, he's just anti law enforcement, and basically he's there to mess over his fellow blue line comrades. And if you do that as a cop, you're basically a rat. A blue rat is one of the names they call it. If you're a blue rat, your career is done for. You'll never be trusted again. You'll never be promoted again. So Trooper Paul had that kind of pressure on him, and you could feel it. He didn't understand physics. He didn't understand any of this. And I believe he doesn't even believe that what he said happened. And he's just told different information about where John O'Keefe's body was, and it's not even the right information. We don't know where it was at because the site was never marked, and he was moved before any effort was made to exactly show where and how he was laid on the ground. They didn't even take pictures of that. At least the world is seeing how bad Massachusetts is. How it's a complete sham. Their justice is a complete sham. It's all politics. I mean, you think the DA's office there isn't political? You know, Morrissey, he was a politician long before he became an attorney. And then he became an attorney, and after he left the state legislature, then he became a district attorney. So he was in tight with the politicians long beforehand. And so, as I understand, he's never even gone to court on any big case as a district attorney because he was able to come in as a basically a middle-aged person, and then he got put in as district attorney, and then he basically had all his underlings do all the trial work. So he doesn't have any trial experiences. All he has is political experience, and that's what you see here is the politics of law enforcement coming out. Have any of y'all seen the that old movie 12 Angry Men, where there's only one person that was holding out for not guilty, and he forced him to think about what was really going on with the case, and one by one, each of the other jurors who voted to convict were then had their own reasonable doubts. So there need to be people like that on this case. I just think there's no way whatsoever you're going to get 12 people to agree that Karen's guilty, even with all the truth being hidden by this court. Jim Glathar, you're saying if you're a defense attorney, how would you react to the Commonwealth's repeated motions to limit defense theories to the case? I'd be talking very loud in the courtroom. I would be very much incensed, and I'd be citing all these constitutional Supreme Court cases and basically be telling them, are you trying to guarantee this thing gets reversed on appeal because you want that conviction that bad? Are you really wanting me to sit down here and say nothing and be ineffective? Because I'll do an affidavit. I'll confess my ineffectiveness to represent my client, Karen Reed, all due to the fact that you have completely hijacked me. You're forcing me to do different defense strategies. Basically, you're choosing the defense strategy and the defense theory for me. I can't choose it based on the evidence I find in my investigation of this case. So, and I would continually challenge a judge in her bias. I mean, they're not, I can't believe they're not doing that more frequently. I would have, every time you get one of these weird rulings, I'd again say, Your Honor, that's another indicator. We note for the record on the appellate courts, this is your attempts to deny us the constitutional right to present a defense, and just continually grill her on that, and build a record. Even if she tells you to, sit down and button it, you need to say, Your Honor, I need to build this for the record. I note this objection again, and always have sidebars when she's denying you stuff. Have the case law ready, like I showed you on that one, Davis v. Alaska, on confrontation, and also on calling witnesses like Easter. I'd request reconsideration and have this Washington v. Texas case cited. So there's more that they could do to fight this. In the end, will it matter? Will she just rubber stamp it still? Well, at least you're building a record. Elizabeth, you're saying, what are the odds the feds come in and arrest the judge and all the corrupt persons? I don't know what kind of evidence they would have on that. I don't know whether they would wait until the trial's over, but I don't have enough information to go on that. So I think it's unlikely, but that would be nice if they found where the corruption string is, where it takes them, and they make those kind of arrests. Leslie's beautiful mind, you're saying the prosecution is too busy defending their witnesses to even argue their own case. All right, somebody's talking about threatening a judge. Nobody should be threatening a judge in terms of, I don't know what that's about here, but oh, you're just saying you want to call and plead that she resign. I'm not going to ask anybody to make any phone calls or anything like that to Massachusetts. Let Massachusetts clean up their own business. But the folks in Massachusetts, they're the locals and all that. You need to keep protesting. Keep protesting the unjust people there that are running the district attorney's office. Montana, you're saying, could the defense be getting a contempt charge because of the strategy to get the judge off the case? They would need their own attorney in a hearing where they could bring up all the bias. You're not challenging the judge and her bias is not going to get you a contempt if you do it respectfully and you challenge her and you bring out all the examples of her biased rulings and you got the case law and you say she's adamantly opposed to following the Constitution and her rulings exhibit extreme bias and prejudice against the defendant. And to the extent the defense counsel can't even argue in their opening statement what exactly happened according to defense theory. I mean, I just cited that case law right there from 1967. It's a landmark case. I cite it all the time. But in Massachusetts, they don't want to follow a case law, so which interprets the Constitution. So go figure. Jessica, you're saying Bev's brother represented Chris Albert when he killed a man in DUI accident. Yeah, I've heard that a number of different times. So that could also be a reason to challenge her. I don't think that they put that in their motion, did they? I recall looking at that motion. I didn't see that raised then. So that could be a grounds right there. Has it been raised before? Can somebody tell me? I don't recall seeing that in their motion. She said she had no connection, but what about her brother's connection? And that's That's too close for comfort. Kate, you're saying, how is Morrissey's connection with the Alberts not a reason for his office to be recused? So if Brian Albert was coming in the office, did some stuff out of that office, and had some dealings with him, that could lead to a conflict as well, a recusal. But I just can't believe the Attorney General's office for Massachusetts hasn't stopped in and taken over this case, shut down this madness. Rosemary Gallagher, you're saying you read some late night, more names that were mentioned with jury tampering and made you really sick. I'm sure that kind of stuff is going on. Is it possible Commonwealth has a plant there on the jury? I wouldn't be surprised. Commissioner senior taxpayer in Massachusetts, you pay her salary. Well, guess what? These cops that are making 200 to 320 some thousand a year. Wow. I mean, we got the highest levels of government. Only the president in the federal government makes more money by salary. So you got filthy rich cops going around town. No wonder they think they're above the law. If you pay them that much, they have the gun and the badge, and they're making more than most citizens in the community. How's that public service when they're living like kings in the community, kings and queens? I thought only coaches made those kind of salaries in states, not public servants and law enforcement. The vice president of the United States doesn't even make that much money. So you got a lieutenant in Canton, Massachusetts, that makes more money than vice president of the United States. There's something wrong with that. Ashley, you're saying, do I think Brennan ultimate motive for demanding the judge to check ARCCA and get a private communication besides the defendant is about gleaning FBI attorney general conversation, what orders ARCCA got? I think they all got this. He would have gotten the same packet of what instructions they were given to the ARCCA team. They had like, what was it, 12 to 14 items they were supposed to flush out in their testing. So I think they got the same thing. So maybe it is Hank's trying to get to what other texts or emails they're talking about. But I think they really were just focused on what information was there to indicate that whether Karen's vehicle is the cause and manner of death for Officer John O'Keefe. I think that was their main focus. And I think there might have been some other views beyond that in terms of how the office handled it, but in terms of corruption, because it also, I think it was done along with that other case, the other murder case out there, the Birchmeyer case, where a young girl was underage and she was having a relationship with a cop, and then she became, after a couple of years, he had her killed in her apartment. And lo and behold, Canton police officers said that it was a suicide, and now the FBI has taken it over, and U.S. Attorney's Office is prosecuting the guy for murder in federal court. So hopefully the truth will be coming out pretty soon here. Keep in mind all these folks running for lawyers, like you said here, timely manner. McAlberts will be running for lawyers. Jen McCabe has the same lawyer as that doctor who just got convicted of manslaughter. He's a high-priced lawyer there outside of Boston. Kennington, I think his name is. These people really fear something. They really fear the possibility that they could be prosecuted. Why would you spend that kind of money if you didn't have anything to do with what happened that night? You were just in the house minding your own business. As I've said before, they need to hammer that home. These witnesses all have lawyers. These witnesses that keep flip-flopping. They can't keep their story straight. They tell blatant lies. They need to call them out the fact that their lawyers are sitting right there in the courtroom and ask them how much they've been spending on that. I guarantee it's in, many thousands and thousands of dollars. If C. Dixie, you're saying Hank is going to gaslight very so hard at every step through this trial. I hope the defense is able to object at all the right moments and avoid alienating the jury. It sets up a hard road. Yeah, well, they need to object because they need to make sure the record's protected. And none of these defense lawyers have what I would say a personality that grates with the jury. The prosecution does. Brennan has that problem grating with the jury, and the way he comes across is not going to be likable to the jury. So that's a big plus for the defense. Colin's speech therapist, the blood in the basement that got redone, and the flooring replaced. Yeah, so in the Albert house, they changed out the flooring in the basement. That's what people have been saying for many months. So there is some evidence like that they need to bring out in trial to again show their suspicious behavior going on with those folks in the house that night. Jim, again, you're asking a case like Karen Reed's makes me question whether the adversary system is appropriate in criminal trials. Do you think this case demonstrates an abuse of the adversary system? It's an absolute abuse. Okay. You can have the best rules out there, the best constitutional framework, the best cases to explain how to treat and interpret the Constitution. But if you have folks that don't have to answer to the Constitution, they just want to do their own thing, and you have a judge that doesn't follow the law, either knowingly or through ignorance or whatever combination, then you have a system that's going to ultimately fail the people involved in that court system, and they're going to ultimately fail the public. So the people of Massachusetts, you're really being failed by your leaders here in the legal system. It's a complete disaster. It's a complete disgrace. And how's it ever going to change? How's it ever going to change? Who's going to step up and do something? Leaders of that state had a chance to step in after the first trial. And you know what they did? They just allowed Morrissey to buckle down and even waste more taxpayer money by spending hundreds of thousands of dollars on some mobster lawyer. And then all under this pronounced guise of they're doing all this to ensure that Karen gets a fair trial. It's all a sham. It's all a sham. Eliza Krognan, you're saying, how did they know there was no evidence? They go into the house right away to check for life or anything. Exactly. It's all just a smoke screen, an absolute indicator every which way you turn of a cover up. Mickey, you're saying the same thing. They never inspected a house. So how can they say they didn't find anything? Mandy, yeah, there tends to be little to no evidence when you don't look for evidence. Ruth Christie, you're saying, are the witnesses allowed to watch trial before they testify? They're not supposed to, but who's going to catch them if they're home alone? I think jurors will be looking at this as well. I find it hard to believe that all 18 jurors are not going to be looking at this at all the whole time they're on seated as jurors on this trial. I think it's too tempting. I just know I've seen it happen too many times where jurors are checking to see, hey, well, what's really going on behind the scenes. So I think stuff like this hiding of all the truth. You may have jurors that find that kind of stuff out there. Andy School, you're saying, yes, 3 liters of blood loss. The average person pumps 4 to 6 liters a minute through the heart. When massive blood loss occurs, the heart rate goes sky high to compensate above 130 beats a minute. Yeah, I think the whole body holds around like 6 to 7 liters. So that means he lost about half his blood. Rosemary Gallagher, you're saying attorneys in Massachusetts have to possibly face this corrupt judges sometime. They want other attorneys out of state to speak up. Yeah, but they could also make complaints. They could send letters and say that they think that this is such a miscarriage of justice and whatnot. But they could then lose cases and get bad rulings as a result if it doesn't do anything. So yeah, maybe they are afraid to do it, but they need to have the courage to step out and make sure something happens to replace this judge through the governor's office or through the legislature to have her impeached. Yeah, I'm tracking that Chris Albert, defense attorney for a guy that killed a man in 1994. I'm tracking that. I haven't followed that case. I heard some really crazy stuff about it, similar to this case, or even worse. I'm hearing. I can't imagine it worse than this one here. Yes, Eliza, that's true, and that's why they kept it out. If that would have came in, I guarantee you there would have been a full acquittal across the board. And that's why they kept it out. And that's why they want to keep it out now, because absolutely these guys can crush the prosecution's experts, so-called experts. And I would not call Trooper Paul an expert. Libby C, if one of the ARCCA witnesses testifying lets it slip that they were hired by the feds, will they get in trouble? Can defense somehow make it known how? There's ways that it could be made known, but the I don't want to suggest any of that. So that's all I'm going to say about it. I mean, people slip out and say stuff they shouldn't all the time. So witnesses being told something they forget or whatever. I mean, it could be an honest for lapse of memory or something like that. But an attorney's not supposed to tell somebody to do that. I can tell you that. It's unethical for an attorney to tell somebody to violate a court order. Okay, so. Colin's speech against saying about the Sandra Birchmore case. Birchmire, I think it is actually M-I-R-E. Corruption run deep until the Karen Reed case. Sandra was swept under the rug. Yeah, it's really corrupt. I'd say the Northeast is probably the most corrupt part of the United States. Hanker, sorry, you're saying it's a way the defense can bring the federal investigation through a back door somehow, like asking our witness who they worked for in the past. I think they should be allowed to do that, but I don't know if the judge is going to allow this, but definitely should be pursuing that line of questioning to lay a foundation for their expertise. Collins, you're saying also the judge called for 16 jurors, and once 16 jurors were found, she wanted 18. Is she planning on dismissing jurors already selected, premeditated? I think maybe she doesn't like someone. Maybe they're sounding like they're too fair as jurors, and she wants to make sure she has other folks to strike as alternates or something. But I think part of it also is legitimate because there was a couple of jurors that they selected, and the next day you hear they lost one. And several times it happened where they lost one. So I do think that this is a situation where if you're going to go 8 weeks listening to Hank Brennan, I mean, this guy, it's like poke your eyes out. Who wants to listen to this guy for that many days on end? And I would think jurors are trying to get off the case. I don't even, I've said they need at least 21. I think you're going to have a real problem. Maybe there'll be another mistrial. I just can't see jurors want to sit through this, guys, dragging this out. And I think it's going to be really, really painful for anybody to sit through and listen to this with him as the prosecutor. Lisa Lee, how are they supposedly not finding the broken pieces before Brian and her family seeing them first? I mean, they came out there how many different times? Like 5 different times over a couple weeks. So this stuff, I mean, you can't make up this crazy stuff. It's just that crazy. It's and they're acting like it's credible and believable, but no jury should believe this kind of garbage. Joy Moore, you're saying, so what are they supposed to argue? That she's guilty, but only of lesser included offense? I mean, they can just say she didn't do it. She's not guilty. Just think the opposite of what the prosecution's saying. And maybe she'll allow them to present, just a few witnesses, and the cross examination will be limited significantly. And I think they're, like I said, from last night's live stream, I think they're trying to keep out ARCCA still. They're trying to find them on a reciprocal discovery technicality where they can either keep them out totally, to have a gotcha moment where they try to catch them in some kind of like misstatement. And in any event, this is nothing but a witch hunt. They're even trying to witch hunt the ARCA honorable doctors who came and testified so brilliantly. Alessi, you're saying 3 liters of blood, but just some faint pink dots in the snow. None of the first responders even knew he had a head wound. It sounded like Dr. Rice didn't either. Yeah, it's just, they never treat it as a crime scene, that's for sure. Because it really wasn't a crime scene, because that's not really where it happened, right? That's why they didn't really want to process it that way. If they had a process like a normal crime scene, guess what? It would have disclosed that he got moved and it was left there. If so, you're saying chance of mistrial 2.0, given lack of evidence. I'd say it's it should be not guilty across the board, but I think it, other than that, it's going to be mistrial. There's no way you're going to get 12 jurors to believe this garbage. There's no way. Yeah. Need to have people that hold out. There's going to be some strong holdouts. If you're from Norfolk County, you better be talking about this case. Let it be known what you think about it. Yeah, 13 Kings, you're saying, why is there no accident report in this situation? That's what Trooper Carolina was saying when I've had him on the channel. And here you have a fatality and there's no accident report. Craig Cruden says the jury comes down to a few alphas and the rest are followers on the jury. Yeah, I mean, a lot of times it is. I think that's what they had. They had the former cop as the judge picked four-person, and he was able to work over a number of them jurors. Ms. Holmes, you're saying defense got to hammer home there's reasonable doubt everywhere you turn this case. I'm going to talk about that tomorrow night. That's the plan. Yeah, why didn't they ask and go to Brian's house? Why did they avoid Brian Albert's house? It was his front yard that they found John O'Keefe. Jam, you're saying they're up against a brick wall because of Canoni and Brennan. Yeah, I mean it's a meat grinder. Going to that court is a meat grinder, and part of the thing that's being ground up is the Constitution. LA, you're saying according to Christy Cetrone, former friends of the McAlberts, the Alberts had a party the weekend after this incident and no one found any pieces. That's interesting. Haven't heard that before. The Meyer League, shocked at how they allowed the family of John to face the accused and the jury. How's this allowed? I think it's very bizarre. That shouldn't be allowed. Him having that mean stare down of Karen. I mean, that's just very much improper. But hey, that's the way they do it in Massachusetts. They don't care about justice and fairness for the defendant. Gracie's mom, you're saying, how can Brennan dictate what the defense team can say or show in their opening statement? Because he's got a judge that's like a rubber stamp whatever he wants to do. That's why I'll do something that crazy. So he really shouldn't be able to. It's not constitutional, as I've showed here tonight. They have a constitutional right to present a defense. There's much more evidence to show what they're trying to propose is more plausible and likely than what the Commonwealth is saying about Karen. Need some Z saying, why do you think the defense has not said the things you've said you would if you were her lawyer? I don't understand that. Well, I mean, a lot of it has to do with this personality experience and what kind of chainsaws and meat grinders you've had to go against folks before. I've gone against bullies most of my military career, different times off and on. Also, as a civilian attorney, gone against different bullies and folks try to railroad your clients and bamboozle and trick the jury and stuff like that. So you just got to have the kind of seasoned experience dealing with that. And so, although I haven't seen as bad as this Brennan guy and this judge, you got to come ready for battle, and you better be ready to do some throwdown there in the courtroom and stand up to the judge and call her out on her bias. Because right now the judge is not afraid of anything the defense is saying, and she's she doesn't even take this case seriously. It seems like the way she's doing sighs all the time on the mic and all her other weird behaviors in the courtroom. It's like she doesn't even take this case serious. And certainly by her rulings, she doesn't take the Constitution serious, I would say, or at least has a complete, utter misunderstanding of what the Constitution means. JC, you're saying, how is it that there are no pictures of the crime scene as it happened? How can this not be disputed? It's obvious that important information has been hidden. They just didn't want to treat it as a crime scene, right? To have in front of a cop's house, just hurry up, get them out of there. Don't process this, and hopefully you'll get Karen Reed to accept guilt. And next thing you know, it's going to be you offer a guilty plea, and then she pleads guilty, and the whole thing goes away, and everybody can wipe their hands of it. But the problem is, she's not rolling over. She's not going to take the blame for it. And the government has to prove their case, and they can't prove their case, and that's why the only way they can prove it is hiding the truth. And so that's exactly what they're going to the ultimate extremes to do. Stevie Howe, there was a case on Dateline. The guy was denied a third party culprit defense. It was overturned on appeal, and he sued and won $6 million. I mean, I think this whole thing about third party culprit defense, where you can get instruction whether you're allowed to do it or not, I think is an absolute farce and unconstitutional thing for anybody to deny what kind of defense you want to put on. If you want to say that John O'Keefe had some other weird, outlandish thing happen to him that doesn't make any sense at all, it's complete nonsense, but that's what your client says they believe happened, you should be able to present that. And if it's so ridiculous and nonsensical, non-credible, non-believable, all those things, then the jury can decide what really happened and judge accordingly. But when one side is, and especially the prosecutor, is supposed to represent justice, just not evidence to convict, but have fairness and the Constitution in mind, and granting the defendant a fair trial and the right to present a defense, when you have this thing being gutted like it has in this case, they should be sued. She should win a lot after she's acquitted. But in a case like that where a third party culprit, you got to have somebody admit to doing it. So unless somebody admits to doing it or they're prosecuted and convicted, just saying that somebody else did it and not having the Commonwealth get behind you or the federal government getting behind you is not going to get you some kind of $6 million verdict. Or no, but it's 10:51. Gosh, I'm way behind here. You guys got a lot of comments. Montana, you're asking, could the defense taking a contempt charge be a strategy for giving judge off the case? They could get an attorney in hearing. They could bring up all the bias in. Oh, they need to be bringing it up every step of the way. And, they could do it outside the presence of the jury. Somebody said maybe that they're doing it at the sidebars. They need to do it in open public forum when the jury's not there and have sidebars challenging her bias rulings. Brennan knows ARCCA guys are smarter than any cross you can dish out. Yeah, I would agree with that. It's all about smoke and mirrors and putting a spin on it. That's what his MO is. Clayton John, the government needs to be flooded with complaints about Canoni. Well, what about Morrissey? Now, I've not seen any ruling by the judge yet on this. On this, basically, it's a gag order from the defense being able to present an opening statement. Yeah, Montana, that's not what I would say is going to work. Bring up a contempt charge for strategy getting her off the case, and they would get an attorney in hearing. They could bring up all advice. No, that's not the time to bring it up, and you don't want to try to go for a contempt. Thanks. Dirty deeds. You're saying the judge doesn't care. She'll not recuse herself. I don't think she will either. And just because she has all these bad rulings, that's not a reason to get a judge recused. Uh, but when you have the volume of these bad rulings in toto, and then you have her coaching the prosecution and her just so one-sided and so much trying to help the prosecution in her rulings, it's just overwhelming, showing she is biased for the prosecution. Yep, I've seen that video. Yes, never seen anything like it. That's actually wrong. It's unprofessional for a prosecutor to be talking about a case that way. But it's Massachusetts, you can get away with it. Meavy, you're saying, can Brennan just file a motion to have the defense hear openings in sign language? I mean, you might as well. I mean, he doesn't want them. The only way Hank Brennan can win is if he bounds and gags and silences the truth from coming out. That's the only way he's going to win this case. So if he was a really high speed, competent attorney, he'd say, bring it on, throw whatever experts you want. I don't care. Bring them on. I'm just going to mow them down on cross examination. I got my own experts. Mine are better than yours. We're going to slug it out. And I know how to be a more persuasive advocate of the truth than anything the defense can muster up. And then you just let the chips fall where they may. But he can't do that. He knows all these signs and tactics that he's doing are an indication to me. He knows he's got a loser case, and he's just going all in on any kind of radical extreme measure he can to try to get the judge to keep the truth out. Buttercup, you're saying you saw the Karen Reed interview by Ted. She was so cool and personable. Why doesn't she testify? Jury would love her. Well, the thing is, if the prosecution hasn't proven their case, you don't want your client to testify. And so, if I have a client that wants to testify and I was like, look, why testify? Because the jury, if they find one thing you say wrong, and they can turn on you and not like you, so why risk it? So unless you really need the defendant to get on the witness stand to really be able to clean up any confusion about the guilt or innocence based on the prosecution's case or your own defense witnesses, because the defendant is going to go last pretty much every single time in a criminal trial. The defendant goes last if the defendant's going to testify or not. So, and I think the issue, like where she said on the steps of the courthouse that you all know who did this, and then another time in an interview with Ted, she says with Alan Jackson, they're saying we don't know who did this. So it's like, okay, you got an inconsistency there. So that's the kind of thing that they could cross-examine her on. So I don't know what her answer would be for that, but that's the kind of thing that that could be a reason not to testify, because then you don't have to get in those kind of explanations, and let the attorney argue what did you mean by that when that comment was made, or what did your client mean by that? Yeah, 300K plus for a Canton Police Department officer. This is unbelievable. Isn't that mind-boggling? Wow. Any of the cabinet secretaries don't even make that kind of money, and you get some lieutenant making that kind of money? Unreal. Four-star generals don't even make that much money. And a Lieutenant Gallagher? Wow. Gracie's mom, you're saying Gallagher retired right after last trial with pension over 300,000? Is that what he's making in his pension as well? That's just obscene. Insane. I agree, Savannah. Why don't you guys change the laws on that? They can't even do rudimentary police investigation techniques, and they're making that kind of money. I'd bring up that kind of money as well to the jurors. They have no idea that they botched it that this bad and made that kind of money. Reddington, okay, that's the name of the attorney for, I believe that's the name of the attorney for Jen McCabe. Shaylee, you're asking, is it too late to bring another motion to recuse? I don't think Karen's ever going to get a fair trial with the judge in charge. Her bias is obvious, and she's holding Hank's hand. I would keep raising it over and over again when I'm getting these ridiculous rulings. Yeah, I think what it may also do is embolden these witnesses that the prosecution's propped up in the first trial with all their different statements of this unbelievable, incredulous type stories that they're saying. Is that when you have a judge that's going out of her way to help the prosecution, it sort of emboldens them in a way because they probably are watching some of this as well, even though they're not supposed to. And then you have them being emboldened and seeing how the prosecution keeps objecting, and they probably talk about don't answer too quickly because then I can have a chance to object, and that way you won't even have to start answering the questions. So prosecutions, when you have prosecutors doing that kind of thing, it's really upsetting. But it's I do believe I recall Alan Jackson calling them out on that, like they got some kind of code. So that's what a good defense attorney needs to do is call them out if there's some kind of code speak going on, some kind of agenda going on between the prosecutor and their witness. Stevie, how you're asking if they're allowed to call out lawyering up. I know they can't call it not testifying yourself. Yeah, so they can't bring out the fact that Karen Reed got a lawyer involved and did not make a statement to the police. And but these other witnesses, the fact that they're not suspected anything by the government's given them complete immunity. They're never saying that there's a suspect in anything. They're saying that they believe that they never had John O'Keefe in that house. So why did they got lawyers in? I mean, I'd make a big deal about that. Okay, Island Girl, you're saying the witnesses with lawyers will just cry because it's because of harassment. Okay, let them talk about the harassment. I would be able to flush that out as well on cross examination. So you're paying a lawyer thousands of dollars. How many? I'd ask them how much they're paying an hour, how much they paid to date, and ask them what the lawyer's telling them. What is the lawyer telling them about the harassment? Why are they in the courtroom watching them testify? Are they being harassed in the courtroom with all the cops around? Why is your lawyer here in the room? So, well, how's a lawyer protecting you? Has he sent any threatening letters or anything like that? I mean, what is a threatening letter going to do? Have you done a restraining order and stuff like that? That's a law enforcement function. So hiring a lawyer to protect you from people harassing you, that doesn't make any sense. Flush them out on that. Oh, Mandy, Colin Albert's lawyer is constantly commenting on the case like he's neutral and he doesn't disclose he's Colin's lawyer. I think I know who you're talking about. I've seen this guy talking about how they try to destroy this young man. He's done nothing wrong and all this kind of stuff. And he's on the news like he's a neutral commentator. I'm like, how would he know that much about Colin personally to vouch for him? So it sounds like he's a personal lawyer. So that must be the guy you're talking about, Mandy. So thanks for sharing that. Thanks, KFG. You're saying, please do a video of all the clips of the judge interruptions of defense versus prosecution. Bonus, all her interruptions of defense, intense examination of hostile witnesses. I mean, do you know how many hours that would be spent up trying to put all those tapes together? I'm not a technical guy on video, right? So I wouldn't be to have the tech skills to be able to do that kind of thing. But somebody who does, man, that would be interesting. I mean, you're basically going to see like 95% win rate for the prosecution and interrupting all the good points as well to try to derail the momentum the defense has on their questioning. Yeah, it's just disgusting. Ashley, you're also saying that you understand the DA and Brennan have been relentless trying to get the side of what kind of scope of work info FBI gave ARCA. If Hank gets their text emails, the DA and Alberts want answers for FBI investigations. Yeah, that could be something that they are really worried about what's the scope of work. But I think with the ARCA, I don't think so much the scope of work. There'd be other things that'd be focused on for corruption because ARCA isn't the one that's examining the DA's office. There's examining the issue with regard to did this vehicles cause the injury to John O'Keefe, Karen's vehicle, that is. John Monaco, Massachusetts governor and AG have been absolutely silent on this abuse of justice. Yeah. Yep. They're all cowards. They don't care about justice. And they're all from the same party. So they all go to the same political events together. They're not going to confront each other on what's going on down there in Canton. GV, you're saying it's only pretrial work and he's made so much. You're talking about Hank Brennan. I think he made $283,000 so far. That's what happens when you hire a special counsel prosecutor. They will milk it for everything they can. They will not want to lose a case. They don't have any discretion. I mean, think about it. If you shut this case down and say, you know what, you shouldn't be prosecuting a case like this, that kind of money would dry up so fast. So, and now he's more into it. Now he realizes, hey, the only way I can really get a win in this case is to just cut them off the knees. Don't let their evidence come in. I'm going to throw the case and lose on appeal, but who cares? I can make my most money now, probably get some political kickbacks and appointments in the process. Okay, serendipity smiles. You're talking about conscious machine being a bully and making threats and being creepy. I'm not tracking that. Sorry. So I'm trying to run a professional channel here. I don't want any cussing, swearing, talk like you're in a courtroom in front of a judge. There's just so much garbage out there on YouTube. I'm trying to stay away from all that. Clayton John, can't be more to be said of Brandon when he makes allegations of defense for trying to surprise him when it's the opposite. Yeah, I mean he's a such a whiner and complainer. It's just I you really don't see prosecutors this bad ever. He's always making allegations of surprise and ambush and all this kind of stuff. You know what? This whole case has been nothing but an ambush caused by the prosecution. So, but yeah, they need to fight back. They need to fight back sternly and aggressively. Call him out on his shenanigans. Sam, you're saying that Delphi case is and was worse. Wow. Okay. I don't know what the status of that one is. Yeah, Delphi's worse, but at least they're trying to hide it. These people operate in front of the world. Yeah, Delphi, I guess that's not on any, they don't allow video cameras, news media in the courtroom doing live streams. That's probably why. Shannon, why would a prosecutor be so determined to try a case when the evidence is extremely weak? Well, the prosecution knows it's very weak, and that's why they had to hire a guy like Hank Brennan to be able to keep the truth from coming in to the jury, cut off the prosecution, the defense argument every chance they get, cut off their witnesses every chance they get, deny them their expert witnesses every chance they get. Just make it where it's just a war of attrition. We're just trying to grind and chew up and just crush everything the defense is trying to do. You're trying to do everything you can to not deny him a fair trial. That's the only chance you got as a prosecutor to win this case. And why do you want to win it? Because that's what you're paid to do. It. You're paid to specifically go after and basically persecute Karen Reed. That's your whole job. It's not to handle a whole caseload of 150 felony cases. And this is just one of many cases. He's specifically hired to target and take out Karen Reed. I mean, that's pretty ruthless, isn't it? The whole process, I think, is unconstitutional. To hire a specific person to take out one individual that lives in the community, you're asking for abuse, just absolutely begging and asking for it. Joanne K, you're saying there's a rumor that someone's going to flip or refuse to testify. I hope the rumor is true. Maybe that's why they're not agreeing to that rule 3 and 4 thing I talked about on who's not wanting to cooperate and who's not wanting to testify. And maybe that's why Brennan's so mad and angry right now because he's losing control, and that's why he wants this thing under wraps as long as possible. Yeah, GB, they can talk about all their other clients. They should talk about even the any of the other feds like the FBI, U.S. Attorney's Office kind of thing. In Montana, you're right. That should be part of their CV. Island Girl, gas lines off the chart. You can't get it much worse than this. I've never seen it this bad. The only comfort I have is seeing number one, how many people are seeing this corruption play out, both in terms of how the case was investigated or lack thereof, how the prosecution has handled this, how they've just tried to derail Karen Reed from a fair trial, both the first time and now the second time is even way worse. So it's good that the world can see it, and if she is convicted, it's not going to hold up in court. JC, yeah, if they do come there with the leaf blower, that would possibly erase the footsteps in the snow. I mean, think about it. That morning, got down to 12 degrees. So they had, I don't even know if it got above freezing that day. That'd be a good thing to know. But if it never got above freezing, maybe those still would be imprinted for throughout the whole day and the next day or so. AJ Lucky Charm, you're saying John bled out in the basement. Okay, well, we don't know because they never investigated it, and that's something the defense should be able to argue. Why can't they argue that? That's what they believe happened. All the suspicious behavior of the folks in the house. There's a reason they're acting suspicious. And if they want to make this argument, they should be able to make that argument based on all the suspicious behavior. Yeah, Manny, reciprocal discovery is ridiculous when the Commonwealth's still turning over discovery. Well, he's been scrambling to get extra experts. Brennan has, because that's his only shot. He thinks he can try to take out ARCCA. But it's not going to work. All right, let's see here. I'm up to 11:15. Wow, I'm a half hour behind. Sorry, guys. Linda Hellcrow, you're saying when John arrived at the house, I think Brian Higgins may have said something about Karen texting him in a fight and said what ended horribly in an accidental death that they tried to cover up. Yeah, it probably, if there was something like that going down, it probably was an accidental thing, and then they got scared and tried to cover it up. So that's what defense should be able to argue. Why shouldn't they be allowed to argue that? It's Constitution required. If so, you're saying you're thinking the judge is softening towards the defense, she's been ruling in their favor lately. I don't understand where she stands. Usually ruled against defense any opportunity. Well, I think part of it's because she's had to, and so it could be also just a lure where she's going to do a bait and switch. So I don't trust her ruling so far, and maybe all the media coverage of this case and how bad of a job she's doing is maybe getting to her, but I don't see much of a fair trial at all. So wow, here's an interesting thing. Carl, I live in Norfolk County. I have good friends that are police officers. They think she's innocent. Wow, that's amazing. I wonder what they are they police officers for other than Canton? They're probably not Canton cops you're referring to. Could you clarify which officers those are? Not their names, but what just say other than Canton. You probably don't want to give the city where they're from, but yeah, BBJ. The fact that Hank is trying to prevent the defense from using a pick of John's arm is telling beyond how much the Commonwealth try to hide anything, hide try anything to hide the real evidence. I mean, it's just so. That's how desperate he is. That's why he used desperate in the title. He's so desperate to keep the truth out. You don't even want to photograph and explain that a dog did it. Also, a random dog did it, but not a dog from 34. Okay, really? He's desperate. He's desperate because he knows he's got a loser case. Alan Jackson's bucking of nickels. There's plenty of exculpatory evidence. Commonwealth just bogs the jury down with nothing burgers. Brennan's dog expert is supposedly going to take over a day. Wear your boots every day. All right, jumping ahead here. Deanna Millard, Brennan has no real evidence, so he's trying to his best to strip Karen completely of her defense. He's vile. I mean, it's bad. It's really bad. JP, you're saying that court clerk Tim also hit someone with his car and caused bad injuries? The only one who hasn't hit someone with a car and can't is Karen Reed. Wow. Yep. Naturally, yeah. Understand that judge's brother was Chris Albert, lawyer for a hit and run. Yeah, I'm tracking that. Eddie Morgan, you're saying Morrissey is more powerful than he gets credit for. Quincy is the heart of Norfolk County, and Norfolk County is the heart of Massachusetts. There's a reason all of our politicians live here. So you're saying Morrissey lives in Quincy? I think I've said that. I've seen that before, where he doesn't live in Kent, but he lives in Quincy. I'm still about 20 minutes behind. Keith asks, please give us more hope for victory. Well, I think even despite all these roadblocks, I think ultimately they're going to be able to present enough, and enough is going to come out at the trial that it's just there's no way they're going to be able to beat ARCCA. So ARCCA should be able to carry the weight no matter what else comes out. And I think also the fact that you have a prosecutor that's just not likable, trying to get other people to dislike Karen. So in order for other people to dislike Karen, he's got to be likable, and he comes across very unlikable. So that's a hard sell. Oh, KFG has microdots for help. Yeah, they've got a lot of great videos out there, don't they? Psychology 9, you're saying also judge knows how to play the game. She must allow some defense issues to look righteous. That could be it as well. I mean, if you just across the board denied them everything, then but she's maybe going to allow an expert, but not allow them to talk about as much detail. She'll find that they don't have the expertise or qualifications or some garbage like that. So It's still very much a rigged system, I would say. Mandy, yeah, where's this funding coming for Hank? How's he able to do that? Ms. Holmes, you're saying, how's it that Canoni answers no one? Thank you. I would say that that's the way judges are, unless they're higher up judges do something and tell them, hey, I saw you on the live coverage of how you're handling this case, and you need some mentoring, and here's what you need to do differently. Unless you got something like that going on, or there's some kind of impeachment by the state legislature, then really the only thing you can do is wait on appeal. All right, so I'm going to go ahead and ask one more question here, and then I'll shut it down. We're getting close to 2 hours. You guys have been great with your questions. Thanks for supporting justice in this case. And like I say, tomorrow at 5 o'clock Central Time, I plan on covering the closing argument. I'm going to go over through that with Alan Jackson's closing, and going to point out some ways that can be significantly improved this go around, and they need to get it right, and they need to get the instructions nailed down. And because if they don't, they could lose this case. Instructions are critical, your arguments are critical. So, Komodo, Indiana, yes, they should ask Easter to be reconsidered. And they should cite the case law like I've cited here on some of my last live streams, including tonight. So they have to be able to present a defense. They should also look at other cases from other federal courts in other states where you've had experts to counter. I mean, think about it. Even in a civil case, if there's a civil rights abuse case, so if, unreasonable use of force by a police officer, let's say a police officer beat some citizen up, and they get sued in federal court, and there's civil rights charges made against them in a civil court, not criminal court. They even have use of force type experts, law enforcement experts that testify for the plaintiffs, explaining what the police officer did wrong and busting the guy's arm, knocking his teeth out, all that kind of stuff. And they bring their expertise to bear, and that's how they help get wins against cities and states and other locales to be able to hold the police officer accountable. Well, here, so you can have those kind of experts testify in a civil matter, but here in a criminal case where they're trying to not just win money against state, but Karen's life is on the line here, where she could spend many decades behind bars, and then you can't have that same kind of expertise brought in. So you couldn't even bring a civil case against unlawful use of force if you didn't have a cop expert testifying for a plaintiff. So here in a criminal setting, the judge is going to say, no, that's not allowed. The jury understands what's going on. So it's just all a scam, like I say. So in any event, with that, hopefully you guys can join us tomorrow night. Have a good, safe Easter weekend, and hope to see you all then. Take care. Have a good night.